Hello listeners, I am Namanpreet and I welcome you all to Ensemble Daily News Analysis. Today's topics for discussion will be: first, new DNA technology bill; second, National Apprenticeship Promotion Scheme; and third, Whistleblower Protection Act. Let us start with new DNA technology bill. The 2015 draft DNA fingerprinting bill is back in a new version and includes some important additions and deletions. Centre is about to finalize a fresh version of the DNA fingerprinting bill, a draft of which was ready in 2015. Law Commission of India released a revised draft of the bill that is now called the DNA-based Technology Bill 2017. Now, what is DNA profiling technology? DNA fingerprinting or DNA profiling is a method of isolating and identifying variable elements within the base pair sequence of DNA. DNA fingerprinting technology is utilized by police all over the world for foolproof identification of criminals who leave their traces at crime scenes while committing crime. The technology plays a crucial role in solving crimes as it has a potential to link a series of crimes by tracing the suspects by linking them with the crime scene. It seeks to establish regulatory institutions and standards for DNA testing and supervise the activities of all laboratories authorized to carry out such tests. Significance of DNA analysis. It is extremely useful and accurate technology in ascertaining the identity of a person from his or her DNA sample or establishing biological relationship between individuals. As a result, DNA technology is being increasingly relied upon in investigations of crime, identification of unidentified bodies, or in determining parentage. But information from DNA samples can reveal intrusive information like their allergies or susceptibility to diseases. As a result, there is a greater risk of information from DNA analysis getting misused. Bill provisions. It prohibits the collection of any bodily substance from an arrested individual without his or her consent, except if the individual is arrested for certain specific offences. However, if the consent is refused without good cause and a magistrate is satisfied of the need for a DNA test, he or she can order the arrested person to give a sample. The new bill has also removed a provision that allowed DNA profiles in the data bank to be used for creation and maintenance of population statistics data bank. While the penalty for misuse of data remains a prison term of up to 3 years and a fine of up to ₹1 lakh, a reference to a minimum prison term of 1 month has been removed. The bill seeks to set up 2 new institutions, a DNA profiling board and a DNA data bank. DNA profiling board. A board with 11 members is supposed to be the regulatory authority that will grant accreditations to DNA laboratories and lay down guidelines, standards and procedures for their functioning. It will advise central and state governments on all issues relating to DNA laboratories. It will also be the authority to make recommendations on ethical and human rights, including privacy issues related to DNA testing. Now, what is DNA data bank? A national data bank of DNA profiles is proposed to be set up along with regional data banks in every state. The new draft does not specify the location of the national data bank. All regional DNA data banks will be mandated to share their information with the national data bank. Certain DNA profiling board accredited labs would be authorized to carry out DNA testing and analysis. These are the only places to which DNA samples picked up from a crime scene can be referred for analysis. Data from the analysis will need to be shared with the nearest regional DNA data bank, which will store it and share it with the national data bank. The data banks will maintain 5 sets of databases for DNA samples picked up from crime scenes, for suspects or under trials, and for offenders, missing persons and unidentified dead bodies. The limitations include: there are chances that a wrong match is generated. If the DNA result is taken as ultimate evidence, no recourse will be available to an individual who has been wrongly matched. Privacy related objections. Main concerns are whose DNA can be collected and under what circumstances, who can access the database, etc. Information like ancestry or susceptibility to a disease or other genetic traits is liable to be misused. DNA tests have not led to an improvement in conviction rate in countries where it is already being followed. Next, let us move on to National Apprenticeship Promotion Scheme or NAPS. Now, what is NAPS? Recognizing that apprenticeship training flags an image, the Ministry of Skill Development and Entrepreneurship has launched the National Apprenticeship Promotion Scheme to enhance the pool of well-paid skilled manpower that commands social approval and recognition. Apprenticeship training prepares practitioners to get certified license to practice in a regulated trade or profession. Government also shares the cost of training imparted. Aim of the scheme. India aims to train 50 lakh apprentices, an increase of 22 folds from present strength. NAPS has a vision to create an industry-ready workforce and help transform India into the skill capital of the world. Significance of the NAPS scheme includes apprenticeship are much more aligned to what companies do as a business and go a long way to address the skills shortage in the industry. They will also be able to learn as well as earn with a valuable insight into the chosen career and will help them make professional decisions more easily. Advantages includes it is an inclusive scheme covering all industries such as manufacturing, services and trade sectors. No paperwork is required. A user-friendly online portal has been designed to facilitate easy processing of an entire apprenticeship cycle for registration to selecting candidates. Access to a vast pool of talent to be selected as per the establishments required. Now, how is NAPS spreading the messages? NAPS is moving ahead to fulfill the vision of a skilled India. The MSDE has adopted a multi-pronged strategy to spread the awareness, which includes the following. First is organizing meetings, workshops with all stakeholders, associations of different sectors and local industry chambers and clusters. Second is appointing brand ambassadors for states and for logical and local industrial clusters to act as a facilitator and promoter to boost apprenticeship training. The monitoring of an apprenticeship training in state public sector undertakings and private sector establishment is to be undertaken by the respective state governments. The State Apprenticeship Council has been entrusted to set up an apprenticeship cell in each state to monitor of the implementation of the scheme. The next topic for discussion is Whistleblower Protection Act or WBP. More than 15 whistleblowers have been murdered in India in the past 3 years. The Parliament has passed the Whistleblower Protection Act in 2014. The Act aims to protect people who bring to the notice of the authorities concerned allegations of corruption, willful misuse of power and commission of a criminal offence against a public servant. But this does not help save their lives as the government has doggedly refused to operationalize the law. The law defines whistleblower as any person or non-governmental organization who exposes corruption. The features include the WBP law has provisions for concealing the identification of a whistleblower. The law empowers the competent authorities to accord them protection, which includes police protection and penalizing those who victimize them. The shortcomings of the Act are: whistleblowers are routinely subjected to various forms of victimization, suspension, withholding of promotion, threats of violence and attacks. Whistleblowers Ram Thakur, Mandi Singh and Amit Jethwa were intimidated and sought police protection in vain before they were murdered. Instead of operationalizing the WBP law, an amendment bill which fundamentally dilutes the law was introduced in the Parliament in 2015 without public consultation. The amendment bill seeks to remove immunity provided to whistleblowers from prosecution under the Official Secrets Act for disclosure made under the WEP law. Offences under the OSA are punishable to imprisonment of up to 14 years. Threat of such stringent penalties would deter even genuine whistleblowers. If whistleblowers are prosecuted for disclosing information as part of their complaints and not granted impunity from the OSA, the very purpose of the law would be defeated. The RTI and the WBP Act. The RTI Act seeks to provide information to people, while the WBP Act provides a mechanism for disclosures to be made to competent authorities within the government to enable inquiry into allegations of corruption and provide protection to whistleblowers. The suggestions here can be: there is no justification for not operationalizing the WBP Act. It is the moral obligation of the government to immediately promulgate the rules and implement the law of offer protection to those who at great peril explore wrongdoing. Hope you find it useful. Thank you.